Manufacturers, MWL's webinar on this topic. My name is Rich Schuster. I'm an associate here. Before I came to MWL, I litigated in Taiwan for approximately 5 years. I wanted to say up front, this format, this sort of medium, is completely unfamiliar and uncomfortable to me. I can't see you. I can't see how bored you look and speed things up. You can't give me feedback through talking to me. So if I make any mistakes along the way, I apologize for that. If you have any questions or want to talk about any of these topics, I'm very interested in other folks' ideas on subrogating claims involving Asian manufacturers and how the industry as a whole can get better. So a little bit about myself. I did live in Taiwan for 5 years prior to moving back to the United States, originally from Wisconsin. Here's some photos of my beloved Taiwan. And you should know that my perspective on all of these topics is shaped by both living in Taiwan, being married to someone from Taiwan, and also representing Taiwan companies and Chinese companies. I do a lot of defense work for both Taiwan and Chinese companies. I help draft supply chain agreements, deal with U.S. customers for them. So all of my ideas come from that perspective, and I hope it gives me some credibility, but also keep in mind, that it's just one perspective. At some point in this webinar, we will ask you a trivia question. So please pay attention to your slides. My trivia question is related to one of the slides. After I ask the trivia question, just put your answer in the question box, and Jamie Breen will monitor who answers correctly first. The person who does answer correctly first, as with all of our webinars, will give that person the option to choose any of MWL's texts on subrogation. So not a bad deal. This presentation is all about the current problem with respect to subrogation claims and Asian manufacturers. That is, subrogation recoveries involving Asian manufacturers tend to be much less successful than with sort of domestic run-of-the-mill property claims. A lot of presenters out there tell you why that is the case, but what I've seen lacking in the seminars, webinars, presentations that I've seen by others in the industry and attorneys is what can be done about it. So these claims are hard. What do we do? Things I want you to consider sort of broadly, not just throughout the presentation, but as you go back to work and are dealing with these claims, maybe you'll get a claim involving an Asian manufacturer 6 months from now, a year from now. What if these claims yielded recovery results similar to domestic claims? I think that's sort of considered to be a far-fetched goal right now, and I don't think it has to be. Secondly, what if Asian manufacturing subro claims were treated as a specialty within insurance companies, subrogation companies, and law firms, much like workers' comp subro and medpay subro? So you had someone within your organization who specifically specialized in handling these types of claims. I think that would be a major paradigm shift, but it might be something that our industry needs if we're going to make these claims hunt the way that they might be able to. The challenges, as I see them, are several-fold, but primarily we need to convince our industry collectively, not just here at MWL. We can't be the only ones touting this approach. We need to convince the industry as a whole to rethink what it thinks it knows about the difficulties in pursuing subrogation against Asian manufacturers. And I think we need to lead that effort by innovating what I call solution-based ideas and going away from the fill-in-the-box process-based practices that we see a lot today. And we need to all understand that, at least from my perspective, much of the reason why subrogation claims against Asian manufacturers have been less likely to succeed than other property claims is simply because of the way we're handling them, and not perhaps by the claims themselves or any limitations of the claims themselves. I want to give some background on both China and Taiwan, because these are the countries in Asia that I'm most familiar with, and one of the challenges I see in dealing with U.S. companies is an attitude or a misunderstanding about the development in these countries. So a lot of folks I deal with at U.S. insurers or for corporate clients here think, oh, that's sort of third world in the middle of nowhere and far behind the United States. I don't think that that's really accurate anymore. Some facts about China that I think are interesting. It didn't join the WTO until 2001. So while it today is the second biggest economy in the world, it wasn't even a member of the most important trade organization, really the only trade organization that matters in terms of getting things done globally until about 13 years ago. And in that time, it went from 5th to 2nd in terms of the scale of its economy. It's the largest export country in the world. I think most people know that. And there's not really even a close second. With respect to legal issues, it acceded to the Hague Convention over 20 years ago. And also, I include on the slide a question, when will it be number one? The consensus among economists and others is that, in the financial sector, is that the Chinese economy will overtake the U.S. economy. And that's significant because you might remember maybe 5 years ago, even 5 years ago, people thought, nah, that's not going to happen. It was sort of this white elephant. The thinking was. Now the thinking has changed, and it's no longer a question of whether China will be the biggest economy in the world, but when. There was a recent report that was on foxbusiness.com or whatever that Fox Business website is, just recently, this week, that said the China economy will overtake the United States economy in size by the end of the year. Now, I don't think that that's true, and most things that I've looked at indicate it's going to be maybe as soon as 2017. It might take as long as 2030. People have different ideas on it, but the point is that at some point the China economy is going to overtake the U.S. economy, and it's not that far off in the distance. So you're talking about a major, sophisticated capitalist player in the global economy. Taiwan, on the other hand, is not nearly as large either in size or population as China. There's about 30 million people who live in Taiwan, and it's heavily invested in technology. So all of the major LED, LCD panel makers are in Taiwan. The largest laptop makers are incorporated in Taiwan. They might do their manufacturing elsewhere, but these are Taiwan companies. And Bloomberg just recently rated Taiwan as the #1 country in terms of patent activity for whatever that is worth. There are a lot of ties between China and Taiwan, for better or worse. Many people in Taiwan, Taiwan declares itself independent from China. China has a one China policy. This isn't a historical or political talk, so we won't get much into that. But there are ties between the countries because of cultural similarities and because of proximity. You know, Taiwan is just off the coast of China, really. And 10% of the labor force of Taiwan works in China. The mainland China, the government is called the PRC, the People's Republic of China. The official state name for Taiwan is the ROC, the Republic of China. And 50,000 businesses in Taiwan are operating in China. I think that's important because when you deal with subrogation claims, you might see made in China on a product, or you might think you're dealing with a China company, a Chinese company. And it's true that that product may have been manufactured in China, but the company that manufactured it might be located in Taiwan, which is a factor you need to consider when you're developing a game plan for how best to subrogate. claims involving Asian manufacturers, you all know, are primarily property claims based on product liability theories. Hotspots right now, I'm sure most people on this call know all about braided supply line issues, plumbing valve issues, Chinese drywall issues. There are other hotspots as well that I've seen, maybe not as prominently as the valves and the Chinese drywall, but things like what types of claims have I seen? Heaters, fans, heated blankets, ceiling fans, those type of things. I've seen claims on them repeatedly. Also extension cords and those power strips that you plug extension cords into, those claims seem to be some of the most common as well right now. Laptops, laptop batteries. If you have claims involving any of those types of products, good bet that the manufacturer of the product is located either in Taiwan, either in China or in Taiwan. The standard presentation with respect to dealing with subrogation involving Asian manufacturers that I've seen deals with why is it so difficult. And my problem with the standard presentation is attorneys or subrogation professionals giving the presentation tell you why it's so hard, but they never give you any solution. They never tell you, okay, it's really hard, but here's how you actually get the money in the door, which is the whole goal. So today we're going to focus on ideas we have that might work for you about how to actually recover on subrogation claims. Before we do that, though, I do need to give you just some background information on why it's difficult. There's three main reasons: jurisdiction, service of process, and enforcement. The jurisdiction cases I've cited in the materials are up on your screen right now. If you have any questions about J. McIntyre, which could be its own topic, but really is overblown in terms of its importance in the subro context, in my humble opinion, feel free to call me, email me. Back when these two cases, which were announced by the Supreme Court of the United States on the same day in 2011, were announced, I gave a presentation at the Alpha Defense seminar. So I have probably a 10-page single-spaced memo on these topics. If you want it, just email me. Feel free to have it, or maybe Jamie can host it on our website. But the point is, I think that these issues are a bit overblown. You need to be aware of them, but they do not determine whether or not you can pursue subro. Service of process, I'm sure you're all familiar with this issue too. Hopefully your attorney has determined, okay, we have jurisdiction over the company, and then usually they tell you how difficult service is going to be. In China, service is not really that difficult. They've acceded to the Hague. What you have to do is you have to translate the documents, which is important as a practitioner to remember when you're drafting the complaint. You try to keep it simple because it saves on translation costs. Taiwan is not acceded to the Hague. One of the misnomers that I've heard, actually in court, I had a case where I was representing a Taiwan company. My adverse said that to the court on the record that Taiwan has not acceded to the Hague because the government is trying to protect its manufacturers from product liability claims. This is not true. Taiwan is not acceded to the Hague because China puts a lot of pressure on other members of the international community not to recognize Taiwan, so it can't officially sign these treaties a lot of times. So, for example, there's no official embassy in Taiwan for the United States. Instead, there is an organization called AIT, Americans in Taiwan. It does exactly what an embassy would do. It's just not called an embassy. So it's not that Taiwan doesn't want to accede to the Hague. It's, global political issues that prevent it from doing so. There's a treaty on there's a treaty that applies to some Latin American countries. I don't do much work, to be honest, dealing with Latin American claims, so I just put the information there for your use. But don't confuse letters rogatory, the treaty, with letters rogatory, the process that you use to serve companies in Taiwan. Costs of service of process depend, as I said, on the size of the materials that you're translating. Typically, we use a service here. Typically, you can send the materials to a company and get service for, I want to say, about $2,000 on a sort of standard case. If it's more complex and your complaint's more complex, then service might be more. You might get away cheaper. You might get away for under $1,000 if you keep your complaint simple. It takes anywhere from 2 months to, I'd say, 6 months in China to affect service. Sometimes you don't affect service. There are still fears of manipulation of the judicial system in China. I don't think it's as big a problem as folks in the United States think, but it does still happen. So there's no guarantee that you're going to get service just because you send it out for service under the Hague. In Taiwan, just so you know, it takes longer, maybe 9 months. It's a bit more expensive as well, and the process is just a bit more cumbersome, the letters rogatory process, but it's not insurmountable. Finally, one issue that hopefully you haven't run into, but I'm afraid many of you have, is the issue of enforcement. What I see a lot of times is insurance companies or attorneys decide to file a lawsuit in the United States without having game planned up front whether or not a judgment is going to do them any good. We won't talk much about that here, but I'll just give you the general rule is that you cannot enforce a judgment in China. In fact, it's more than a general rule. I don't know of a single judgment that's ever been enforced in China stemming from a U.S. court. So it's not going to happen. This topic is ripe, though. You can see on your slide I have the Sanlian decision there. If you're familiar with Sanlian, I'd be interested in your thoughts on that case. If you're not familiar with it and would like to discuss it, we'll be doing an article or having more information on this case in the future. But basically, this is a California case from, I think, 2009 that enforced a Chinese judgment. So sort of opened the door to what we call factual reciprocity, all very very legal and not really the point of this presentation, which is how do we get money in the door. So we won't focus on it, but just know Sanlian is on our radar. It should be on your radar as well. Now, I say those things to highlight this point. That is, the basic presentation that tells you why it's difficult to litigate against Chinese, Taiwanese, other Asian manufacturers. All that helps you do is decide whether or not you should pursue litigation. It does not tell you whether or not you should pursue the claim. But what I see oftentimes is if you've reached what you think is the end of the road and you've decided, okay, we cannot litigate in the United States, files just get closed. And I'm here to encourage innovation so that the files don't close at that early stage, and that we at least try other strategies to collect on them, because we've had success in doing that here on some claims. So where have we gone wrong? I think the standard approach in the industry is pretty well known. If this isn't your standard approach, I think it might be similar. Usually, company sends a notice letter to the prospective at-fault party. You don't hear anything back. You follow up many times. You don't really know what to do at that point, so you refer it to an attorney. Maybe the attorney takes a flyer on it. He or she sends a demand letter to the company, maybe follows up with some threatening letters, and then at some point you have a conversation, the attorney and the claim handler, what do we do now? And the attorney will either say, well, we file suit, and hopefully they've done enough work up front to tell you why you should file suit and why you can enforce if you receive a judgment, why you can enforce it. But oftentimes that's not even the discussion. Otherwise, it's determined, okay, well, I guess we're going to close the file. The reason that I think that the standard approach doesn't work, and this is more of a cultural-based analysis on my end, I don't know if it's right, but it's just my own anecdotal experience, is that our system is very adversarial. So the initial notice letter that you send out, the initial letter they get has already blamed them for the problem. There's been no dialogue. There's just a conclusion. Hey, you did something wrong. Pay us our money. Here's our address. Send us the check. And what I tell folks that I work with oftentimes is that if you pick a fight with an Asian manufacturer, you're going to get a fight with an Asian manufacturer. I don't think anyone deals well with that sort of threatening tone in a letter, and we probably do it too much as an industry, even on domestic claims, but it really doesn't work with respect to foreign claims. And the way we approach things, having not game planned well enough up front and just using our standard approach no matter the set of facts we're dealing with, that not only encourages a do-nothing response, it's basically built the do-nothing response. The only reason that do-nothing response has cultivated among Asian manufacturers is because we as an industry have let it happen because we haven't planned well enough in advance. So anyway, the last point I would make on this area is that you need to make the decision whether or not to file suit in the United States based on whether or not a judgment's going to do you any good. Our approach at MWL, we now call the Asian Claim Recovery Program, and it tries to use alternative processes or alternative strategies to the sort of standard approach that I outlined previously, and to alternatives to U.S. litigation. Now, we might litigate in the U.S., but we would like it to be sort of as a last resort, or we like to have made the analysis up front that that's the quickest, cheapest way to get the most money in the door for the client. And we rely on what we call levers, and then we create a game plan, and then we implement that game plan in phases. I'm very much, as I said previous, interested in others' thoughts on our approach, how we might even improve what we do, how what we do comports to successful plans that you might have, and how we can get the industry as a whole to start thinking in these ways. So just know that up front. I'm really interested in what you have to say. I wish this was in a medium where that could, where there could be more of a dialogue. So what is a lever? A lever is not a legal term or an industry term. It's just a term I use that means it's anything or any person that can move a company to act. It's the button that you push that gets a result. And the way that you find levers, you have to know what levers you're dealing with before you can game plan. Because the only way to make a successful game plan is to know what's going to motivate this potential adverse company that we think owes us money for a product liability claim to action. The two ways I know to find levers are through research, which anybody can do, and then through using relationships you have on the ground in Asia, which I know might be limited for some of you, but some of you at subro companies or claim handling companies, if you're at Sedgwick or Crawford or Cunningham or Gallagher, you know folks and you have folks on the ground in Asia probably who can help you in cultivating levers, building a game plan, and ultimately in resolving claims. When we research levers, this is a non-exhaustive list of what we're looking for. And the answers to these questions are going to tell us not only what motivates the company, but it's also inevitably going to answer the questions, well, do we think we have jurisdiction over the company in case we need to litigate in the United States? Can we achieve service on them? And even if we do this, is a judgment going to do us any good? Can we enforce it? Don't just limit yourself to enforcement in the United States. Even if you're dealing with a Chinese company, through research you can find out, hey, does this Chinese company have a factory? Do they have offices? Do they have assets, accounts receivable in South Korea, for example? Because, hey, South Korea, they will enforce a U.S. judgment as long as you obtain it properly. So maybe we don't even have to worry that it's a Chinese company. We can enforce directly in South Korea, perhaps. That's just one example. So these are things we're looking for. Obviously, if you can find insurance, in my experience, my belief is you're basically halfway home once you find insurance. It's just a matter of getting the insurance company to understand the claim and why they need to pay you. One last point on research. Don't limit your research to the product line you're dealing with. Here's an example. This is actually a defense file, but when I was in Asia, was hired by a company that was defaulted. It was an ATD claim, it was a product liability claim for a personal injury action. The Taiwan company, it was odd circumstances, but the Taiwan company never even got notice of the claim. Very suspect doings in the Southern Court. They were sending notices to an address that was literally XXXX, and then the second line was Taiwan, Taipei, Taiwan. So obviously it never reached the company. But the point is, the plaintiff in that case, once they defaulted the Asian manufacturer, they found out that the Asian manufacturer, they didn't just make ATVs, they also made component parts for the automotive industry, and they garnished accounts receivables from clients, from customers in a northern state. That's bad for the Asian manufacturer for two reasons. First, they don't get their money, and second, then their customers start asking questions. No big company in the U.S. wants to be dealing with a foreign manufacturer that's having garnishment issues and things like that. So they jumped on that right away. And the point for our purposes is just that don't limit your research to the actual product line you're dealing with, because sometimes these companies, they specialize in manufacturing, so they can make just about anything. With respect to connections, I've listed some connections that might be useful if you have them. It really depends on who you are as a person and your experience and background. For me, if you have access to brokers, I would say brokers are a tremendous resource. And here's a point about brokers. Insurance companies love brokers as opposed to what they think about claim handlers and attorneys, because brokers actually generate revenue for insurance companies rather than being a cost center. So if you can get an introduction to a manufacturer's insurance company through a broker friend, your broker friend is going to know who insures the company, even if they're not the broker. This is their business. You know, they're going to want to try to be that company's broker at some point in time. So brokers know a lot of information is the point there. But trade groups, industry groups, buyers, they all might be levers that you can cultivate to get access to companies, which is ultimately what you want. So once we've done our research, we develop a game plan. Initial questions that we ask, as I said, is litigation possible and is it practical? You know that analysis just by being a subro expert or an attorney. So we don't need to focus on that. Here's what we focus on. What do you do if you've determined litigating in the U.S. is not a good option? And as the slide says, this is where I think our industry has really failed. You need to be creative. You can't rely on the standard playbook. You already know it doesn't work. And in fact, it actually has hurt our industry. You need to rely on your levers in forming a game plan. There's no one answer, unfortunately. It's all lever-based and it's game plan-based. You need to make a plan based on the specific facts and the people that you can gain access to with respect to that claim. I put some general concepts that work. One big point is you need to communicate a problem and a need for a solution rather than communicating a demand or being so authoritative in demanding money. I think that works well for us here, is trying to be problem solution based in dealing with the adverse and not being demand negotiation settlement based. We're always willing to meet in person. I know that's not possible for some of you folks, but it does help. So our game planning is divided up into 3 phases, and as I said, it's all based on levers, and basically we're trying to establish contact, meaningful contact, gain credibility, and then resolve the claim. That's how we break it up. Sometimes you don't get past phase 2, or it takes a long time to get past phase 2. Sometimes it happens quickly. These are, unfortunately, very claim specific. So the research into your levers, identifies, hopefully, the context that you need. So who is someone within that company that faces the United States? Maybe it's a salesperson, and they have connections at the retailer. Or if you don't even know who the retailer is, maybe they're in charge of handling relationships with the distributor. Maybe you know the distributor, and they can get you in contact with someone at the company that matters. Maybe you have a friend within insurance who knows who's the insurance company for the company, or at least can tell you they don't have insurance, which isn't good news, but at least it helps inform your plan. All I'm trying to do in researching levers and in phase 1, I'm trying to find out who at the company is the person I can work with to fix this problem. Sometimes you don't find that person, in which case you have to cold call. Remember, when you cold call them, and I know most people online probably do, you need to be respectful because you need them. You want money from them. They don't need you, and they're probably not excited to hear from you. Let's take a break just real quick before we go any further. I need to give the quiz that I forgot to do a few slides back. The quiz question for this presentation is on slide 7. There is a photo of a city. Identify the name of the building featured prominently on slide 7. Excuse me, it's slide 8. I'm sorry, slide 8. If you have the answer to that question, put your answer in the question box and email Jamie Breen, and she will let us know at the end who the winner is, and you can contact us to get your free book of your choice. Okay, picking back up where I left off. Sorry for that interruption, but picking back up where I left off. In phase 2, I've found out who the person is. I've had a friend in China or in Taiwan introduce me to the company. Maybe it's a broker, an insurance friend, someone in a trade industry. Maybe one of my clients knows someone who worked or used to work at the manufacturer. You just dig and you find someone who can connect you to that company. And then all I want to do is build what they call guanxi. Now, if you're familiar with Asian culture, this is a real elementary concept, but if you're not, maybe just a word on guanxi is that it means basically relationship. And just as in the United States or anywhere in the world, relationships matter in Asia. I think that they're particularly important in business in Asia, whereas in the United States, things tend to be transaction-based. Oh, do you have the lowest price? Can you provide the best service? Okay, you win the contract. It's not quite so simple and transaction-based in Asia. Things take longer to develop because deals you need to be trusted before you can enter a deal. So even if you're the lowest cost, best service provider, if you're trying to enter into a contract, you might need to negotiate a deal for several months or even longer in the context of a transaction to build enough guanxi so that the company feels comfortable enough to go forward. That doesn't really seem to be the case in my experience in the U.S. So it's very important. The phase 2 can take a call, one phone call. It can take 2 phone calls. I've had a situation where I called, an attorney had been calling, or excuse me, had writing letters for months. Never picked up the phone, of course, because maybe he didn't even have access at his firm to dial internationally. Some places don't. I know a lot of insurance companies don't. And he couldn't speak the language, so I'm sure he just felt uncomfortable doing so. I picked up the phone. I did not know who I was calling. I had no ties to this company. But I navigated their phone system, and I got someone on the line. And I explained the problem. I actually apologized for the other attorney sending so many letters. The lady who I was able to talk to, for whatever reason, was just happy that she could deal with somebody who could speak at least some Chinese. Now, around here they say my Chinese is fluent, but it's not. I'd say we say proficient. means if we're talking technical information, I'm going to get lost easily. But I at least could have a conversation with this young lady. One more call to her boss, and we got the claim paid. So sometimes this guanxi can develop quickly, or you don't need a lot of guanxi to take care of a small problem. Sometimes it can take a long time. I wrote in an article that we published recently, I had a claim involving a laptop battery. I happen to know some folks at the insurance company for the laptop battery maker. This was a file that was written off by a lot of people. We organized dinner with both the insurance company and the manufacturer in Asia. Nothing really was discussed at dinner about the claim, nothing at all. And the next day, we got an email from the insurance company advising that the money would be wired. Now that's its own set of problems for some insurance companies to receive wires from Asia, but it's a good problem to have, really, if you're getting money in the door. So sometimes these things can develop quickly, but other times they take a long time. I would encourage you not to force things. Take it slow. Know that some of these things are going to take you quite a while to resolve. And unfortunately, sometimes you never make it past phase 2. And I don't say that to say you never ask for the money. You always do. But sometimes you just haven't built up a relationship where they trust you, or there's internal problems at the target where you're never going to build up that relationship. Phase 3 is really just an extension of phase 2, in which we're discussing in detail the problem, which is the potential defect, and we're requesting a solution. If it's a big matter, or if I think it will help, we use intermediaries to help informally mediate. So maybe we have a go-between. If you have access to someone like that, that can be helpful. And remember that everyone likes a deal. That's why I think that subro claims are particularly well suited. Asian manufacturing claims are particularly well suited in subrogation, because in subrogation you're dealing with sophisticated clients, insurance companies who understand that if you receive 100% of your claim 4 years from now after expending a lot of time and resources, that's no better than if you recover, some lower percentage of the claim today in real money. Insurance companies understand that, so they're willing to negotiate sometimes and to give a deal. And Asian businesses really like to feel like they got a deal. So I think it's particularly well suited for negotiation if you can, as I say, if you can find the right levers, and if you can build a relationship. I want to talk for a moment about the do-nothing response. I hear a lot about this. You send your letters, you try to call the company, you do whatever you can, and it just doesn't matter. The company doesn't respond. I fundamentally believe that the do-nothing response has found a home and is the standard response for a lot of companies because we've allowed it to work, meaning they've known from the start you don't have service, you don't have jurisdiction, or you don't really understand the law in that area, and you've made a mistake just fundamentally up front. That happens a lot. So early on, they decided to do nothing. Maybe they were afraid, maybe they didn't know what to do, so they did nothing. I'm talking 10, 15 years ago. Well, you never pursued the claim, or insurance industry never pursued the claim, because ultimately they discovered they didn't have jurisdiction, or they couldn't affect service, or maybe they did all that and then they realized, oh man, we can't enforce the judgment, or they tried and they couldn't, but the plan worked for them. They did nothing, and ultimately, through skill or bad luck, their plan was successful. Nothing happened. So over time, word of mouth, industry, they're not dumb over there. They realized, hey, we ignored it, it went away. You should ignore it, it'll go away too. I fundamentally believe that is the source of and the reason for the do-nothing response. But if you game plan properly, usually the do-nothing response won't work. However, sometimes even if you do everything you can, they still will do nothing. And we're going to have to force companies away from that strategy. And one of the ways that we're working on to do that is through a willingness to pursue manufacturers to their doorsteps in China or better in Taiwan. Whether or not you file suit in Asia, the key is a willingness to do it. So as long as they know, as long as you've built up enough of a reputation that they know, hey, these folks really will come right to our doorstep and litigate in our backyard, that can help you to resolve claims. Along those lines, just a few words in the last few minutes to give you just a bit of a primer on civil procedure in China and Taiwan. Both in China and in Taiwan, the judge is the finder of fact and the finder of law, so there's no juries. The judicial hierarchy in China starts with what's called the basic people's court. There's 3 levels of court and then the Supreme Court. Depending on the size of your claim, you can file suit directly in the intermediate people's court. So you don't always have to go to the basic people's court. An important thing to consider when determining whether filing suit in China might be a plan of action to consider is that part of the filing fee depends on the size of the claim. So unlike in the United States where the filing fee in California is $465 or whatever it is today, and that doesn't matter if you're litigating a multi-million-dollar business transaction or you're litigating, you know, a small rear-end car accident PI claim, it's the same price. Not so in China, also not so in Taiwan. I've laid out for you a couple of the levels, so you know RMB is the Chinese currency. It's about 8-to-1 right now, so 8 RMB is about $1. So you can see if for claims value where you're seeking 500,000 to 1 million RMB, the filing fee, part of the filing fee is 1% thereof. Now, if you take the case all the way through final judgment in China and win, you can get that filing fee back. The defense will have to pay it. However, as you know, most cases settle. And if you settle, you don't get it back. It's just baked in. You need to bake it into whatever ultimate settlement you have so you know what your net's going to be, because you're not going to get that money back. The substantive laws that apply to product liability claims in China are primarily the PRC tort liability law, which was enacted in 2009. This law was a specific reaction to the melamine milk scandal that occurred in 2008-ish, I want to say. I'm not sure if that was big news here in the United States, but it was in Asia. And basically what happened is some very, I'd say, evil people were tainting milk and baby formula with chemicals, and I don't know the ins and outs of what happened, but I know I think 6 children died in China, and thousands or at least hundreds of children became very ill. And as a reaction to that, the consumer public in China demanded stronger rights with respect to product liability. Another result of that melamine milk scandal, just to highlight the differences between the U.S. and China, is I think within like 3 months of that scandal unfolding, one of the perpetrators of the scandal, one of the heads of the companies that was responsible for that, was publicly executed. So, you know, they don't mess around. That's their version of due process, and you can know for sure that was a warning to other companies that if you make unsafe products for children, you can pay the ultimate price. So that also highlights, you know, a lot of people in the United States think that China, Asia in general, make really low quality products. I would argue that's not really true at all. One of the reasons that products might fail is just because of volume, first of all, and also the U.S. retailers have a role to play in this issue. They continuously are looking for cost savings, cost down, which means you have to make products 1 millimeter thinner. You have to make wheels just a bit less robust. You have to make plastic just a bit less sturdy. So there's enough blame to be shared on all sides, but it's the result of the Western appetite for cheaper and cheaper products in large part, not a result anymore of an inability in Asia, a lack of sophistication in manufacturing or something. That's just not really, it doesn't really exist anymore. Another source of law is the product quality law, which was the basic law since 2000. It breaks product defects into two categories, what they call flaws and defects. These laws are translated into English, but the English does not apply. So you can't rely on the English, but it will help you if you just want a basic understanding. Lastly, on China, there are still concerns over outside influence over the judiciary. So just be aware of that. I don't recommend litigating in China unless it's a last resort and you have a very strong claim. Taiwan, on the other hand, it's similar in that it has no jury trials. It has a judicial hierarchy similar to China, similar to the U.S. too. And also in Taiwan, the filing fee is based on the amount that you're seeking to recover, similar in part to China. Taiwan is a civil code, so there's less emphasis on case law, sort of precedent, than there is in the United States. In Taiwan, unlike China, the government is willing to enforce a U.S. judgment. So you can get a U.S. judgment and take it to Taiwan for enforcement. But I caution you, you better have made sure that you've gotten the judgment properly in the U.S. under Taiwan law prior to doing so. This is important because a lot of times what you'll see is a marking that says made in China, but what you don't know is that company might be headquartered and incorporated in Taiwan. So you can enforce a judgment in the United States in Taiwan if you've done it correctly. They'll look for reasons to kick your case, as will U.S. courts when they're dealing with foreign judgments. So you need to make sure that you do it right, that you've reviewed the Taiwan law. I've laid out what you need to do to make sure your judgments are good, but obviously if it's an important case and you're going to go this route, be sure to touch base with that law, be sure you're familiar with it or that you're working with somebody that's familiar with it up front. I would even say bring in the people that you're going to use to enforce the judgment on the front end so that they can give you some guidance so that when you get the judgment you can go back to them and say, hey, we did everything you said, now go do your job in Taiwan to get the judgment enforced. That's all I have. I'm going to try to take a look at some of the questions now. Just give me 1 second. I'll go over these questions if I can find them on my little box here. Maybe if Jamie's listening, maybe she can come in here and help me to see where these questions are located. I don't know. There was 3 original questions as well. Okay. One of the questions here is from Deidre. It's from Deidre. And her question is, are there contacts within MWL that communicate with foreign manufacturers for us? Yes, definitely. I would be that contact. Aaron Plowman also does a lot of this work. I communicate in Chinese. Someone else here. There's another question right below it that says, say something in Chinese. 你要我说什么，我都可以说。很开心你们参加，我也很开心你们给我这个机会，可以跟你们讲这个很重要的事。Basically, I just said, what do you want me to say? I could say whatever you like. Thank you very much for attending today and giving me the opportunity to talk to you about this topic. I think it's important. So yes, there's definitely context here. Another question here, Christy. I have a claim involving alleged defective product resulting in a fatality. I don't know what the question is, but I'm sorry to hear that. I'm not sure what the question is there, but if you need any help, just give me a call and we'll try to help as best we can. One of my problems is I can only see the questions on the screen like one line at a time. I do see that there are many questions here. I don't know why I can't see them in a better format. It's my problem. One question that I can see, what statute of limitations applies to product if we are looking at service being 2 to 9 months? Well, the statute of limitations and service are two separate issues to the author of this question, and obviously the statute of limitations depends on the state in which you're attempting to litigate. Most states are 2 to 3 years. Some states are longer. I think off the top of my head, Missouri is one of the states with the longest statutes. Some states, bear in mind, also have statutes of repose. Florida, for example, if you're dealing with a product that's over 10 years old in Florida, be mindful of the statute of repose. Army, if you have specific questions about the statute of limitations that you're dealing with, I guess contact me or contact someone that you trust about the state you're dealing with, and they can answer your question. I see a lot of questions. Jamie, can you tell me who won the? Oh, here it is. The trivia winner, so everyone knows, is Stephen Tate with Travelers. Jamie will be contacting you, so you can choose your book. Just so everyone knows, I'll go back to slide 7 real quick, or slide 8. The building depicted in the slide is Taipei 101, which was the tallest building in the world for quite some time. It's right here. If you don't know, Taipei 101 was overtaken by some building in Dubai as the tallest building in the world. However, it's pictured here on page 4 too. If you, I'm not sure what happened exactly, but the building in Dubai might not be open yet, so it might still be the tallest building that actually is in use for commercial purposes. But anyway, here's the photo I was talking about. This is a picture from a place called Elephant Mountain in Taipei. This is the downtown city of Taipei, but Taipei is a very, very sprawling city, huge city, about as big as Chicago in actual population, but the surrounding communities make it much, much larger than Chicago. Anyway, we're at 1 hour and 2 minutes. I'm really sorry that I can't see some of the questions very well, but I promise I will get to every question that was asked once Jamie shows me how to do it, and I will write to you by email. If you have any questions, please feel free to give me a call. If you have any ideas on what our industry might be able to do, please let's get together, let's roundtable some things. We don't have all the answers on our end, and the point is, I hope that we can, as an industry, develop better approaches than we have now, which don't seem to be very successful. And I really think that we can. It just might take some specialization, some innovation, and some grunt work on all of our collective parts. I really appreciate your time today. I hope that you were able to take at least something from the presentation. I apologize if I bored any of you at all. It's a foreign format for me, so I use that as a crutch. Thanks very much once again. I hope everyone that's in the Midwest can get out and enjoy the weather. Enjoy the weather today. Take care. I'll be stopping the recording now and also stopping the presentation. Thanks very much. Bye now.